Good afternoon, everybody. Welcome to the Federalist Society section on property rights and environmental laws, discussion of property rights in America today. It's a pleasure seeing everybody here. I just want to do a quick announcement that if anybody from the Society is interested in joining the executive committee or learning more about it, there will be a meeting upstairs after the session here in the Madison room. I promise that I'm going to have no virtue in what I do today. I was asked to be a moderator, and I've never been called moderate before. So I had to look that up and see what that means, and I remembered Barry Goldwater said that defensive liberty, moderation in the defense of liberty is no virtue, so I will be moderate and I will not be virtuous. I'm going to give a quick introduction to the topic of property rights and the debate over property rights, and then I'm going to introduce the speakers, sit down, and we're going to go into their opening remarks from the podium, and I will answer questions of the two distinguished gentlemen here today, and then we'll open up to questions at the end and promptly at 1 o'clock. So my point was that the debate over property rights is certainly of long standing, and I'm going to give you some quotes, not in any particular order, that take both sides, because I'm trying to be moderate, on property rights. So I'll start with John Adams, who said that the moment the idea is admitted into society that property is not as sacred as the laws of God and that there is not a force of law and public justice to protect it, anarchy and tyranny commence. On the other hand, Paul Proudhon said property is theft in 1840. George Bernard Shaw said that a government who robs Peter to pay Paul can always depend on the support of Paul. John Locke said that whenever legislators endeavor to take away and destroy the property of the people, they put themselves into a state of war with the people, who are thereupon absolved from any further obedience. Thomas Hobbes, on the other hand, said, "It is necessary to lay down this right to all things that people would otherwise have, and be contented with as much liberty against other men as he would allow men against himself." Joseph Story, Supreme Court Justice, said that the sacred rights of property are to be guarded at every point. I call them sacred because if they are unprotected, all rights will become worthless and visionary. James Madison said that when an excess of power prevails, the property of no sort is duly respected, no man is safe in his opinions. And we can go to, my next quote here is actually from one of our guests. Stephen Reinhardt said in a William O. Douglas lecture back about 7 years ago, "There are exceptions, of course, to the Supreme Court's preference for the interests of the state over the rights of its citizens. First and foremost, the court is protective of the right to property and indeed generally appears to be far more concerned about that right than it does to the right of liberty." Al Gore said that the environmental problems of our society are the consequence of too much protection given to individual and property rights. William Blackstone, "There is nothing which so generally strikes the imagination and engages the affections of mankind as the right of property, or that sole and despotic dominion which one man claims and exercises over the external things of the world, to the total exclusion of the rights of any individual in our universe." Richard Lazarus, Professor Richard Lazarus, who has argued on a number of cases at the Supreme Court on behalf of governments, writes, on the other hand, that nor does the court today appreciate that over the past century our relationship to the land has fundamentally changed. Law is now a highly regulated commodity, and the ownership is no longer a touchstone of human autonomy or the source of individual freedom. Helen Caldecott, formerly of Union of Concerned Scientists, said that free enterprise really means that the rich get richer. They have the freedom to exploit and psychologically rape their fellow human beings in the process. And I will close with, excuse me, I get this here, just a couple more. Freedom and property rights are inseparable. You cannot have one without the other. That's George Washington. But I will leave you with Jean-Jacques Rousseau, who in a treatise talking about the understanding at that time of the origins of property right, there was the idea at one time of early society of mankind there were no property rights, and that evolved into something that we now know as property. He said, what crimes, wars, murders, and miseries, and honors, and horrors would the human race have been spared had someone pulled up the stakes and filled in the ditch and cried out to his fellow man, do not believe in this impostor. You are lost if you forget that the fruits of the earth belong to all and the earth to no one. You'd never hear me say that again. But I want to introduce our speakers right now because we have two very distinguished guests with us today. We have Honorable Stephen Reinhardt on my left, really. Stephen Reinhardt is a graduate of Yale Law School and Sonoma College. He was appointed to the bench in 1980 by President Carter. He's published numerous articles in various topics relating to the law. Following his graduation, he was a lieutenant in the United States Air Force. He has some reputation of being somewhat liberal in the court. California lawyer recently had a cover story, an article about him titled "The Last Liberal." And this is on this introduction. I hope you won't be offended if I read this, but James Dobson called him the most notorious liberal judge in the most radical court of America. That, of course, is our Ninth Circuit. I prefer to call it the most interesting of the circuits. And I mean interesting in the concept of the Chinese curse, may you live in an interesting circuit. Judge Alex Kozinski, to my right, is now the chief judge of the interesting circuit. And he was appointed in 1985 by President Reagan. He graduated from UCLA, received his BA in 1972 and his JD in 1975. Prior to being on the appellate bench, he had a number of appointments and offices in the Reagan White House. He was an attorney in Covington and Burling, no relation, and he was a clerk to Chief Justice Berger and Judge Anthony M. Kennedy. And with no further ado, we'll begin with the justices giving some brief remarks, and then we'll have some questions from me, and then questions from the audience.
Thank you, Jim. Do I have a mic here? Good afternoon. Great pleasure to be here. What a great convention it's been. Well, it's sort of surprising that we are having this kind of debate, but I think it's a good point as well. The question of whether or not property rights are individual rights or whether they are somehow separate from life and liberty, it really is a question that probably could only come up in America. In other places in the world, those of us born under communism, those of us born under and have lived under other systems of government where property is either severely limited by the government or practically non-existent, realize full well as a matter of daily life that you really can't have liberty. And in a real sense, you can't have life without property. We are not ethereal beings. We don't live from ideas alone. Air can't feed us. We can't develop ourselves materially or spiritually without the use of property. So the idea that if you don't have control over your means of survival, if you don't have your control over your resources to help you get an education, to help you conduct your business, to help you live your life, if you don't have those things at your disposal, you really don't have freedom at all. You don't have any real rights. Your life is at the disposal of whoever does control those things. And we take these things for granted in the United States. We live in a blessed country where it's second nature. It's like breathing. Owning property is like breathing. It's part of your birthright, but it's really a very precious right, And one of the founding fathers very well understood was part of the concept of individual liberty and individual autonomy, and that's why they have provisions. You know, they have just as many provisions dealing with property as they do dealing with, let's say, speech. And yet, as we know, the courts, and I have no problem with this, have created a huge edifice dealing with the right to speech, which I support. I think speech is very important. Having come from a place where speech as well as property was severely limited, I must tell you that I am greatly in favor of it. We have a clause, the religion clause of the Constitution, and they are really no more expensive than what the Constitution is about property. And yet we have a great edifices in the law dealing with protection of the right to religion and the prohibiting the government from establishing religion. And for the most part, I support those. I think those are important. I mean, the right to worship, the right to have a free relationship to one's God is fundamental to human existence. But when it comes to property, courts have been less generous, and this goes to a more fundamental criticism I have about the way our approach to constitutional law, and that is that we take constitutional provision one at a time. We don't ever weigh them all at once. So we get a case involving speech, we get a case involving religion, we get a case involving property, but we never have to compare them one with the other. And what that does is it gives judges a chance to give vent to their own predilections. You know, judges like speech. Conservative judges as well as liberal judges. You know, we're really very keen on speech, and so we have a great edifice supporting that. When it comes to rights of criminal defendants, which again I think are very important. I think any of us might become a criminal defendant, whether we do anything wrong or not. This is one of the great protections of a free society, that they can't come after you. The state can't come after you just because they don't like your face, unlike a lot of other places in the world. And judges have been very protective of that. But judges are not very protective of parts of the Constitution that they find unappealing. Look at the neglected Second Amendment. Now, we may get a little more enlightenment on that score, but the Supreme Court hasn't looked at that, has looked at it once, I believe, in our constitutional history. And judges just generally don't like the idea of guns. So we've sort of pretend it's not there. Judge Reinhardt and I had public disagreements on this in a case by the name of Silvera. And so property is another area where a lot of judges feel it's sort of a second-rate right. This is a kind of right that really is not very important. It's not on a par with life and liberty, which are sacred. The property case is okay to the extent that the state and the political branches of government wish to allot you an entitlement to it, and if the political branches don't, the judiciary hasn't got much to say about it. I think that's wrong. I think the Constitution, we should not be playing favorites with constitutional provisions, and I particularly think that the general judicial disdain to property rights is not justified, and I don't think it's faithful to the constitutional scheme. Thank you.
Judge Reinhardt.
Judge Kozinski says he's surprised we're having this debate. I'm not sure quite what debate we're having. Nobody is proposing to abolish private property. The question is, to what degree does property exceed in importance rights to liberty or life or other rights? What we do in this country mainly is balance various rights when they come into conflict. It's very easy, if there's no other interest other than property, to protect property. It's very easy, if there's no other interest other than any amendment in the Constitution, to say, yes, I'm for that amendment. The difficulty comes when rights come into conflict. Before I get into that, I ought to say I am a great believer in that statement by Barry Goldwater. I think it's one of the great political statements of all time. I wish I could quote it, but it's something like liberty in the moderation in the pursuit of liberty is no virtue. Something in pursuit of vice is no extremism. It was made at the 1964 Republican Convention.
And you must have voted for him.
I was listening. Just as last night I was listening to the Democratic debate while you were all off at your dinner. It was interesting in the debate because the moderator kept trying to get the candidates to say, are you in favor of liberty over security? Well, that's a constant problem. In one of Judge Posner's recent book, he talks about why we should sacrifice liberty for security. I think we can have liberty and security. I also think we can have property and other rights. But they sometimes come into conflict, which is when our problems arise. When the right to property comes in conflict with the public interest, that's when the problem arises. I think it started at the very beginning of our Constitution, when the question was individual rights against property rights. And slavery won, because property rights were determined to be more important than human rights. That was wrong. It's hardly the only time people have had to give up certain property rights in order to have liberty. Now, whether all rights are equal is an interesting question, which I've been debating with Judge Kozinski publicly and privately for years. Yes, I do think that life and liberty are more important in the balance than property. I think that human rights are more important than property rights. They're all in the same clause, but until my first debate with Judge Kozinski before a Federalist group, I wasn't aware there were people who thought that property was important as liberty or human life. I'm still not persuaded. Maybe it's because I didn't go to the gala. But I'm still not persuaded that property is as important as human rights or life. I've seen this debate occur in the public interest, in the public wheel, for many years. As I said, the first time I was not around was when the property right to slaves was more important than the right of every human being to be treated as a human being. The next time I'm aware of that debate was when the New Deal came into being in this country. And the debate then was whether, when you had minimum wage laws to protect children, all of the social welfare legislation of the New Deal, whether that was unconstitutional because it interfered with property rights. Well, fortunately, until recently, the entire country, Republicans and Democrats and others, understood that the social welfare legislation affording individuals the governmental protection that they needed was more important than the abstract concept of employers' rights to make children work 12 hours a day, pay them 5 cents an hour if they could get away with it, that there was a reason for social legislation. Ronald Reagan ran for office on the basis that he was like President Roosevelt, and that was his hero. Well, I think Ronald Reagan understood the need for social welfare legislation. It's not until recently that those in power have begun to challenge that. But I saw civil rights legislation adopted in this country over the violent objections of conservatives who said it was an interference with property rights, that you couldn't have legislation that said everyone had the right to equal access to hotels, to luncheon counters. I saw people stand up in the South defending property rights so that they could keep blacks out of their establishments. Well, that was the debate that went on at that time. Is it property or individual rights? So you have this debate occasionally in this country. And frequently, the answer is yes, individual rights are more important than property rights. Now, the idea is to try to accommodate all of those rights. The idea is to try to see that the entire Constitution is vindicated to the extent possible. But it's when those constitutional rights come into conflict that sometimes you have to balance them, sometimes make a choice. And I guess my disagreement with Judge Kozinski is that you don't always try to, or you're not always capable of giving total abstract predominance to every single right. It doesn't work. There come times when we have to balance, when we have to try to see that the most important interests are vindicated and protected in this country. And sometimes that means that we will have to modify the extent to other rights, and that they aren't just given total protection as if there were no other interests. We have a variety of interests in this country, people's interests, property's interests, that all have to be balanced and harmonized, and at sometimes some yield to others. Incidentally, before I close the opening, I just wanted to say, despite that article in the California Law Journal, I am not the last liberal. I'm the last, possibly the last liberal around at the moment, but there will be a lot more liberals, I assure you, in the future.
Part of the problem is talking about these things in the abstract. This idea of balancing against other sort of other values, it reminds me of a German saying, which is, I think it's available in other languages. It's easy to pull hot chestnuts out of the fire with somebody else's hands. And it's easy to make decisions about public policy and to serve these other values so long as somebody else pays for them. And just to bring it down to a concrete example, take the case of Lucas from the Supreme Court. This is the case, you recall, where the guy owns a couple of pieces of property on the beachfront, and South Carolina says you can't build anything on them at all because we need this beachfront access, and it's an important public value. Now, you can go on the land, you can sort of look. You're free to pay taxes. Thank you. We don't have any problem with that. If you want to tell people you own the property, you can tell people you own the property. You can take pride of ownership, but you can't build anything on it. And he went all the way to the Supreme Court, and the Supreme Court says, well, when you take that much property, you regulate the property. The state of South Carolina affected the taking, took the property, because basically what they were doing is they were taking it for public use. They were using it for the public to sort of have access to the beach. So it's as if they had bought the property and created a beach access. Well, afterwards the case comes back and they do what's necessary and they pay Lucas. And now the state of South Carolina owns this property. And of course, they say, well, now that we own this property, we'll provide it public access to everybody so they could go, get to the beach, right? They say, no, wait a minute, this is really valuable beachfront property. And they sell it to a developer. No joke, this is a true story. It's very easy to make these kind of decisions if you have the power to use somebody else's, to extract the value of somebody else's property, make public policy decisions, because there's almost nothing that isn't sort of a good deal if you'd be willing to pay money for it, if you can get it for nothing. So there's no value, there's no public value that isn't readily served so long as the public needs to pay nothing for it, so long as the cost is imposed on individuals. And that's how these things usually come down. It's never a case we'll take your property or we'll take your life, or we'll take your property or stick you in jail. It is usually your property rights against some nebulous interest that somebody on a city council or a state someplace has decided is very, very, very important. Not important enough to pay for it. Not important the way you decide in your life is important when you decide, am I going to go out and buy something? That kind of important. It is important like, gee, would it be nice to sort of break this window open in the store and take it home? If you could do that, there'd be, there'd be a lot more window shopping going on. Anyway.
Thank you. Judge Reinhardt, do you want to respond to that, or should we move into the question?
I thought we were just having opening statements.
Yes.
And then,
Well, this was rebuttal.
That was a sua sponte rebuttal, and who am I to stop a judge from talking? I've learned too long I can't do that. So you can have a sua sponte rebuttal.
No. We'll move on to your questions.
Okay. The first question is one that I've wanted to hear the answers to in a debate like this for about 17 years, because the basis is a 1990 decision.
What's to you? Kidding.
And I've been waiting so long. A 1990 decision out of Lake Tahoe dealing with some property right issues up there. And it was a case where Judge Reinhardt wrote a majority opinion and Judge Kozinski was on the dissent. And the particular passage gets at the question of, want to know the panelists' views of the relevance of the constitutional framers as opposed to our own views on the importance of property rights and the adjudication of property rights-based cases. And the quote is, the framers of the Fifth Amendment saw the wisdom of enumerating life, liberty, and property separately, and few of us would put equal value on the first and third. So to what degree should originalism animate our discussion of property rights? Judge Reinhardt?
Well, I don't have the benefit that Justice Scalia has of knowing what the original founders thought about everything. So I'm not in a position really to say what they thought about these problems. I had thought that the Constitution was a series of general principles that we were supposed to interpret over the years as we learned more and more about society, and we learned more and more about human nature, that they were wise enough to give us this set of principles so that we could, with knowledge and the developments of life and science and the difference between the country as it was in 1789 and the country as it is today, that we have more knowledge, more experience, and that we could take those principles and apply them to today's problems. I didn't think that they thought they could solve all those problems for us in that time. But if I were to try to determine what the Founding Fathers thought about property, I would have some difficulty. You read some quotes before. Another quote about property from somebody I would think you would have some respect for would be Thomas Jefferson, who wrote to James Madison, "The laws of property have been so far extended as to violate natural right. The earth is given as a common stock for man to labor and live on." Now, I don't know what that means about how the Founding Fathers would decide the kinds of cases we have today, how they decide Penn Central or Loretto or any of those cases. You know, I can get general concepts from some Founding Fathers. Thomas Jefferson disagreed with James Madison. How you find out what, it's not a single person. It's not like reading one of President Bush's signing statements. The Founding Fathers had a lot of different views, particularly once you get beyond their saying, yes, property is important. Well, everybody would say that. When we get to the types of practical problems we have today, I don't think it's very easy to find out through original intent how the Founding Fathers would have addressed today's issues.
Well, it's funny, I should mention Justice Scalia, because about 20 years ago I was at a event, Federalist Society event, and it was right before Justice Scalia was nominated to the Supreme Court. I think it may have been the very weekend before. The following week he was nominated to the Supreme Court, and he stood up and he gave a speech, and he said, I want to speak against original intent. And the room fell silent. But he actually spent an entire speech speaking out against original intent. I don't know if Gene Myers in the audience remembers that, but I'm not sure many people here would be old enough to remember or would have been present. And he said, it's not intent, it's meaning. This is not an exercise in psychology or in historical psychology. We don't ask the question, what did Madison have in mind? What did Jefferson imagine about the internet? Not that he had the internet. These would be meaningless questions. This is why we have a written constitution. We don't have to imagine what they thought. They wrote it down. Now, it is true, as Judge Reinhardt points out in Tahoe Sierra, and I didn't contradict him in my dissent, the statement that Jim quoted, because it was I thought it was so self-evidently disproving. Yes, the Founding Fathers enumerated life, liberty, and property separately. Well, that's because we don't have an English word that means all three things. And I don't know of any other way. Now, today you might have a hyperlink, or something, to put them all in the same place, or something, But in those days, you had to, write them one after the other. And usually when you wrote them one after the other in a series, and you had an and connecting them, they meant that they sort of go together. They are meant to be part of the same group, part of the same. Apply the same level of generality. So I'm not troubled by questions about what would Madison think, or what would gee, in which order were these things listed? The question I ask is, does the constitutional text, as illuminated by some of the papers that are available during the ratifying conventions, to some extent. I'm not so much concerned, it seems to me, with the drafters. It seems to me as important, or perhaps more important, is what was said about these provisions when the states ratified the Constitution. That seems to me a far more significant source of enlightenment. But in the end, really all that ultimately matters is what they wrote down on paper and what they all agreed on. We cannot engage in psychology in interpreting the Constitution any more than we can or should engage in psychology in interpreting statutes. I mean, God only knows what Congress thinks, if it thinks at all. It seems to me that the fact that the Constitution refers to life, liberty, and property in one breath suggests to me that these are values that the Founding Fathers found to be both very important and also made of the same timber. That there are aspects of human existence. You can't have one it's sort of like love and marriage. You can't have one without the other.
Well, there are two things to say about Judge Kozinski's rather simplistic presentation. Number one, merely because words are in the same document does not mean they are of equal importance.
I'll give you the answer.
I guess I understand what Judge Kozinski said is, yes, they're in the same line, and therefore the same timber, he says. Well, the question is, when they come in conflict, are they equally important? I already addressed whether I think when they come in conflict, they're equally important. The answer is no. I think we've had a history of times that they've come into conflict. That's the question. The other question is he reads the Constitution. He says, and there's the answer. Well, what does the Constitution say about life, liberty, and property? You can't take them without due process of law. Well, you read due process and you know what that means? What the Supreme Court said about 150 years later, they said, what is due process? They said, it's a process that is due. Well, that's a wonderful explanation. It doesn't get us much farther than what the reading the document does. Reading the document doesn't answer the question. It doesn't tell you what due process is, which is the key. That's what we've been interpreting ever since. What kind of process is due, and what is due process for life? What is due process for liberty? What is due process for property? We've had a changing view. Previously, you didn't need a lawyer in a criminal case. We've said now that's not due process. People are entitled to lawyers. Our concepts have changed over the years. And fortunately, I think we've grown in our understanding. We didn't look at the Constitution and say, well, it was due process in 1789, so it's due process now. We didn't read it and say, well, everybody knows what due process means. That's a term that comes to have meaning as society changes, as society learns, as we have greater right and respect for the individual in this country. That's why, despite what Judge Kozinski says, the founders, if they had an intent, did not intend us to apply a document, and they didn't try to spell out what due process meant. They didn't try to spell out what all of these basic rights meant, because they understood that we would learn as a society grew. We would become better, we would improve ourselves, and we would have a better understanding of individual rights.
We see there's some dispute on these federal judges on the role of property. I want to go to a specific question dealing with the role of the judiciary, and that is, are constitutionally based property rights issues worthy of federal judicial involvement, or should such claims be heard only by state courts? Which one of you like to start? Judge Reinhardt?
Well, I'm a great believer in the federal courts for a number of reasons. I believe in life tenure, fortunately now, but I believe in life tenure because it makes judges independent. It allows them to do what they think their duty requires them to do. I said a number of years ago in a speech to the Beverly Hills Bar that I had talked to some Southern judges, state court, Supreme Court justices, and they told me quite honestly that they didn't feel free to vote for a capital defendant because they'd lose the next election. You don't have that in the federal judiciary. Federal judges do what they believe to be right and what they believe their obligation is. We may differ on what we think our obligation is. We may differ on what we think is right. But I haven't met any judge in the federal courts who disregards his duty for any reason. I think everybody tries their best to do what their oath mandates them to do. In the state courts, some try, but particularly in capital punishment cases. We had a Supreme Court justice in California who was an excellent justice and highly respected by all sides. And he said deciding a capital punishment case is like, trying to ignore an alligator in the bathtub. You try to put out of your mind the fact that you're going to come up for election. And you try to do your best, but never are you really without the political pressure that lies in the background when you decide these cases, and when you know the law and order people are there watching you. And in our courts, they were there for quite a while. It's not as much now, but even in the trial courts, they were there taking score on the individual judges and how well they enforced law and order in their view. That's the problem you don't have. And that's why I believe that federal courts are better able to protect individual rights and property rights. Now, whether property rights cases are so important that they're entitled to be in the federal courts when our Supreme Court and Congress sometimes don't believe that all cases should be in federal court, and whether they're more important than criminal cases, which are very limited in federal courts. So I'm talking about states cases where we are talking about state law. Now, property law is basically state law, and for that reason, the Supreme Court has said when you're talking about takings by states and local entities, you should first let the state court go through its the states interpret those rulings, whether a taking occurred, whether there are exceptions, whether there are variations or variances. You should go through the entire process and then see if there is a state remedy, whether the state provides relief. And only then should you come and answer the federal question. Well, what do they do in habeas cases? In habeas cases, they say it doesn't matter whether the state action is unconstitutional. Federal courts should ignore the violation of constitutional rights unless two things. One, the Supreme Court has previously held a very similar act unconstitutional. If they haven't held it unconstitutional before, then the fact that it is unconstitutional doesn't matter, and you recognize whatever the state has done. Secondly, they say, unless the state's unconstitutional action is unreasonable, if any rational state judge could come to that conclusion, then you still defer to the state courts. Well, I don't think those advocates of property rights feel the same way about property. As long as we have this kind of a view of people's constitutional rights who are being held in jail or executed unconstitutionally, I'm not sure we should prefer property rights over those individual rights. Personally, if I had a choice, I'd like to see property rights as well as individual rights and human rights vindicated by the federal courts, regardless of what the state courts have done, as long as it's truly unconstitutional. I'd like to see equality among those rights. As long as we don't consider the individual rights of people to be worthy of full federal court protection, I'm not sure whether I would prefer property rights over that.
Thank you.
Well, the reality is there's only one kind of federal right that can no longer be litigated in federal court, and that's a takings claim. You can raise any other constitutional claim, but a takings claim you simply cannot now get in federal court at all. Not for a minute, not for an hour, not for subject to state preemption or anything else. It's very simple. In 1985, a Supreme Court had a case by the name of Williamson County, and what they said was what Judge Reinhardt said: if you're going to have a takings claim, you got to go to state court and make sure that you don't get compensation from the state, because if there's a regulation of the property, but the state will compensate you for it, of course there's no taking. The state hasn't taken your property if it has a remedy where you can go in and get paid. Make sense? Okay. Well, 20 years later, in a case by the name of San Remo Hotel, they said, well, but while you're in state court, you got to raise you can raise a taking claim. State courts can consider federal claims just as well as the state courts can and must consider federal taking claims just as well as the federal courts. And so while you are there, you can raise a taking claim. And in fact, you must raise a taking claim. because under the doctrine of collateral estoppel of most states, every state in the Union, in fact, if you could have raised a claim and failed to raise it, you can't then raise it in subsequent litigation. You can't then come to federal court and say, well, I litigated my state claims, the question of whether I get compensation, but I reserved my right to litigate the federal claim in federal court. Supreme Court said you can't do that. So you either litigate the federal claim in state court, in which case you can never bring it in the federal court, or you don't litigate it in state court, in which case you can never bring it at all. So if there's one claim with one kind of federal right in the Constitution that you cannot, in fact, now bring in federal court as of 2005, it is a claim for the taking of property. It's just a startling result, and much as Judge Reinhardt complains about habeas and exhaustion and all those things, I mean, the fact is, if you're a prisoner and you complain that you don't like the food in prison, you can bring a claim in federal court. If you think that your right to worship in prison wasn't properly observed, or you claim that you were mistreated or anything of that sort, and I don't denigrate those claims. I think some of them are quite serious. You can definitely get into federal court. You complain about your conviction, you can get into federal court. You have to hurry about it. You have to exhaust your state claims, but ultimately you will get federal judges looking at those claims. One claim you cannot get, and that is a takings claim after St. Reba. At least that's the way I read the Supreme Court opinion.
Well, there are two things I would disagree with Judge Kozinski about. Number one, yes, you can get into federal court with a conviction if you hurry about it. But as I said, even if your conviction is unconstitutional, you can't get relief in the federal courts if it wasn't unconstitutional according to a direct Supreme Court decision at the time the unconstitutional action was taken. And two, you can't get relief if the state court decision is unconstitutional, but a reasonable judge, whatever that means, could have made an unconstitutional decision. So you don't get relief for an unconstitutional conviction in federal court. Secondly, I just don't read San Remo the way Judge Kozinski does. This shows how lawyers differ and why we keep going on with cases that end up 5-4. As I read San Remo, the court said that the plaintiff didn't have to raise his federal claim in state court. It could have been preserved, but they went beyond where they had to go, and if they had limited their claim, they would have been able to go to federal court. Now, we can pick sentences out of San Remo, which may appear to contradict, but that's just the run-of-the-mill Supreme Court decision. In any event, I don't give it the narrow preemptive reading that Judge Kozinski did, and I don't think that was the intent of the majority.
That's how Brother Willie Fletcher reads it.
Well, I don't always agree with Brother Willie Fletcher, I can tell you.
At this point, I am going to stop my questioning, although I had a number of others, and ask for questions from the audience because we only have a few minutes left. And in the interest of time, I encourage all the very brilliant lawyers and legal scholars out there to make these into questions, and a question does not mean a long speech followed by, would you comment on that, please? Let's turn these into questions. Thank you. First.
Thanks. Ilya Shapiro from the Cato Institute. Judge Kozinski, a couple of weeks ago when you had another debate on Federal Society debate on property rights, you essentially read the first part of the Takings Clause as prefatory as the first part of the Second Amendment, and the only operative clause, if I'm understanding your argument, is the Just Compensation Clause. How do you square that with what you've just said about the importance of property rights and how they shouldn't be treated as distinct from life, liberty, and the kind of bifurcation that Caroline Products created? Thank you.
Just the same way I read the Second Amendment. I think the Second Amendment has a prefatory clause talking about militia, but the operative language is the one that says, talks about restriction of the right to bear arms. Same thing in the Takings Clause. I think the part that says for public use is descriptive and not proscriptive. And the real punch is, you get paid. The government takes your property, but you get money for it. Money that you can then use to buy other property, send your kids to college, take that long-awaited European vacation, whatever you want to do with it.
Next question.
Judge Reinhardt, I'd like to ask you, what makes you and judges more generally, what in the Constitution gives you the right to decide when society has changed rather than the people through the elected branches?
Just our duty to interpret the Constitution. It's unfortunate that the Constitution needs interpretation, but it was written that way. That's our system. It was not, and I think it was wise, if we want to look at the intent or the meaning of the Constitution, and we want to go back and look at the original decisions of Justice Marshall. It's been apparent from the day we adopted a Constitution that it was not self-interpreting or self-executing, that it needed to be construed as time went by. And, and just as in the elective system, you can't put every public policy question to the public and take a vote on, should we raise this tax, should we lower this tax, should we have a date to withdraw troops, should we raise the cap on Social Security? Why shouldn't the people decide all those questions? The country wouldn't function very well that way. We have the initiative in California, and I think it's proved not to be a very good way to run the state. But if we tried to go to direct initiatives nationally on every issue that had to be decided by Congress, we wouldn't function well. And the same thing with interpreting the Constitution. The system from the beginning has been that the courts have to interpret the Constitution. And that's the way it is. There may be a better system. Maybe we ought to put every question that now goes to the Supreme Court to the public. But I don't think it would be very practical. I don't think that was what was intended, and I don't think it would be a good way to run a country.
Roger.
Yes, Judge Reinhardt, I'm Roger Pilon with the Cato Institute. You spoke in the outset of your remarks about the conflict between human rights and property rights as though they were ubiquitous. But as we know from cases like Lucas, the only reason you have this conflict is because legislatures are prone to give the public rights over what people previously thought were their rights. And you would have the court, as I understand it, bow out of this and essentially defer to the legislative branch to extinguish willy-nilly these property rights. How do you justify that, given that the Constitution gives you the authority to say no to the legislature when it does violate these pre-existing rights by creating these new rights out of whole cloth?
Well, I don't really want to go into the details of
I noticed that.
No. I don't want to go into the details of when the courts can determine that a legislative action is arbitrary and capricious.
We're not talking about administrative law here.
No, I'm talking about these kinds of cases, property cases. As you know, the issue is now before the courts of whether, in addition to the takings, there is also a constitutional right to invalidate some of the property decisions in legislative acts on the grounds that they're arbitrary and capricious.
Say it's substantive due process. Go ahead, say it, Steve.
Well, now, I'm trying to avoid the issue because, as I said, Justice Kennedy, I don't remember which case it was recently, Lingle, said that there is a remedy in the courts when the legislative action is arbitrary and capricious. That case is now in front of our court, or that issue is now in front of our court. In fact, we just issued a decision which is not final, and we may all have to vote on.
That's right.
So I don't really want to get into that question of what the authority of the federal courts is to invalidate these legislative actions on the ground that these takings may be arbitrary and capricious, rather than simply a question of just what Judge Kozinski says. You take it and you pay for it.
There's an English word for that. It's called theft.
Well,
Okay, we're going to have one more question. Oh, and I should quickly point out that case you're talking about, you don't have to vote on that. That's okay. It's our case. So. One more question, and then there won't be enough time for any further questions, and then if we have 30 seconds left, we'll have some final remarks by our panelists. So one more question.
Okay. Judge Reinhardt, you had suggested a connection between private property rights and the system of slavery, and it caused you to distinguish private property rights from individual rights like personal freedom. Isn't it the case that under certainly the Lockean theory, classical liberal theory of private property rights, first and foremost, private property right is in oneself and one's own property, one's own labor. And as a result, it might be suggested, or I might suggest, that in fact the classical liberal tradition of private property undermined slavery rather than supported it.
well, that may be, but that was a debate among those drawing up the Constitution, and that was a debate up through the Civil War. The issue that was advanced by those who favored slavery was that they had property rights. They may have been wrong, but what I say is that it has come up with some regularity in this country that when we have had rights of equality, individual liberty, all of those things, that the debate has been that no, we have property rights has been the other side. Maybe they were wrong, but those are the debates we have had as we've tried to make progress in this country. Each time the issue has been raised that we're infringing on property rights.
I'd like to just have our panelists give some final thoughts. We have to clear out of the room because they need to clean up the lunch plates for the next session. I was told that we must get out promptly by 1 o'clock. So
I'm going to cede my time to the audience.
Okay. I just have one other quote that I would like to read from a 1922 Supreme Court decision, Pennsylvania Coal, which has been repeatedly reaffirmed, the last time in Lingle, which was a unanimous decision, which says government hardly could go on if to some extent values incident to property could not be diminished without paying for every such change in the general law. That's an observation by all sides in the Supreme Court that we should keep in mind as we discuss these absolutist views of property. I am not in any way opposed to property rights. I'm not sure I would agree with Judge Kozinski that the only thing you have to do is pay for them. But I don't think these issues can be resolved without the kind of normal balance we apply in the law to most of the issues that confront us these days. And more, I think what we find, more and more we have difficulty in resolving issues, not only in the courts, but in political life, because they're not just how do you vindicate a right. That's a very easy question. The issues more and more are how do you balance these rights? How do you reconcile them? How do you resolve them? And how do you try to preserve, to the extent possible, liberty and security? How do you try to preserve, to the extent possible, property rights and individual rights and the public interest? I don't think we can resolve any of these questions by saying property trumps all, or even, and certainly we can't resolve it by saying security trumps all. All of these issues seem to me to be getting more and more difficult, require more and more judgment and more understanding of the need to try to accommodate conflicting interests and conflicting values.
thank you very much. Let's give a hand to both of you.